In previous videos, we talked about a case called Payton v. New York out of the U.S. Supreme Court. What that decision said is a police officer who has an active arrest warrant for a subject who's inside his or her home has the right to enter into the home to retrieve that person and bring them to justice. But a lot of people are confused. They think this only applies to felony cases, and the fact of the matter is, it doesn't. The confusion stems from Payton v. New York being a felony case. People read that case and think it only applies to felony warrants, but that's simply untrue. People adamantly argue that it has to be a felony warrant in order for police to have authorization to cross the threshold of the house to go retrieve the subject. But it doesn't. Many lower courts have examined this, even here in New Jersey, and said that a warrant is a warrant is a warrant. As long as it's issued by the court, it's deemed to hold the same value to enter into the home. So what does that mean? It means it doesn't matter whether or not it's a misdemeanor or a felony. As long as the warrant is issued by the court, it carries the same authority to enter into the home as a felony warrant does. People don't believe it, but it's true. Police officers have to remember that they have to follow the rules of the court when executing warrants for people's arrest. They're no different than search warrants. So time of day that matters, knocking and announcing. This is important stuff you need to recognize when executing a warrant for somebody's arrest. Oh, P.S. Nobody's telling you to go knock down doors with $75 seatbelt warrants. We're saying the legality behind it is factual and true. Sometimes we have to take action like that to achieve larger law enforcement objectives. And if that's the case, your action would be perfectly valid.